I seek your lordship indulgence in mentioning item number 9 and 10 of the part 2 hearing list. If these two matters may kindly be taken up on Friday, if time permits.
What about the other
I
side,
have taken
council?
consent.
Have you informed?
I have taken consent,
Yes, on Friday?
my lord.
Okay, we'll make an
If time
attempt.
permits, my lord. Obliged.
Permit.
Your Lordship, to item number 9, I would like to seek in the number
9,
4, item number 5.
5.
Yes,
Yes.
I would like to seek indulgence on behalf of my senior advocate to mention this matter on this coming Thursday.
Thursday. Okay,
Yes.
both of you be present.
Will be any verse planned.
Yes. Thursday, both of you be present. This Thursday, isn't
Yes,
it?
yes.
Noted.
Thank you. That's so blessed.
My lord, part 2 item number 7. Miss Mary is taken leave and may this matter be taken after the vacation?
Have you taken the consent
Yes.
of the other side?
Yes. Yesterday, they told me that Miss Mary had taken leave.
Okay, mention is made on behalf of, no, you're here, isn't it? Ms. Jacinta Moy, learned counsel for the petitioner, has prayed for adjournment of the matter with the consent from the other side. In view of the above, lest immediately after the ensuing vacation. Yes.
After 24th of September, Miss Mary will join on 24th of September, October only.
So we'll make it after 4 weeks.
5 weeks, my lord.
Okay, after 5. You get the petitioner, so it's cool, huh? Okay, instead of vacation, list after 5 weeks.
Mr. Police.
Motion, item 1.
Yes.
May it please your lordship, my lord.
Your Lordship, before the petitioner council start, so I would like to one request. This matter may kindly be passed over for a day, for tomorrow, or at least afternoon too, because here they pray for stay of that examination proceeding.
We'll issue notice first, and
My
then the stay can be considered in
My
the
lord,
short date. We can fix a short date. Let's see
No,
what the
yes,
case
yes.
is about
No,
first.
In
isn't
fact,
it?
your lordship, I'm not
Yes.
pressing for stay, but my only interim relief which I'm praying for is that we may be allowed to participate in the
Can it
recruitment
be
process.
taken up tomorrow
For
or
example.
afternoon?
We'll
Let
issue
me
a
start-
notice.
let me start
Okay,
anyway.
start first. Let's
Yes.
see what's going on.
My lord, the present matter is regarding denial of our opportunity to participate in the recruitment process, examination for 3 posts of motor vehicle inspector under Transport Department. And your lordship, this is a covered matter. This similar issue had already been disposed of by the coordinate bench in the principal seat. So I have annexed the copy also, my lord. Your lordship, I have annexed the advertisement.
Yes, advertisement.
Advertisement
yes,
is at page 59.
Yeah. What does
It was
say?
issued on 10/7/2025. And let me take your lordship to serial number 6, my lord. Qualifications. Has your lordship got it?
Yes.
ma'am? Qualifications, page 56. It says that HSLC with 3 years course diploma in mechanical automobile engineering from government recognized institute. Page 59, my lord.
This is, yes, page 59.
59, serial number 6. This is the serial number 1 is the name of the post, motor vehicle inspector, and serial number 6 is the qualifications. It says HSLC with 3 years course diploma in mechanical automobile engineering from government recognized institute, and this is in line with the recruitment rules, which I have annexed at page, my lord, I have annexed at page 53. Then the relevant portion is at page 57, my lord. 57 at column 8, your lordship. This is the exact sentence is given. HSLC with 3 years course diploma in mechanical engineering, automobile engineering from government recognized institute. And so we are the bachelor degree holders, and we we do not possess this 3 years course diploma in automobile engineering, mechanical engineering. But despite that, Your Lordship, we applied for the post because we are having the higher educational qualification. And since we heard a rumor that we may not be allowed to participate, so we had inquired through RTI, and the reply is at page 111, my lord, 111. This is the question is, I will not read the question. The reply is only diploma holders are allowed to apply and face the exam for this post. Degree holders cannot face the exam. And the reason is also given in the online RTI reply. That is at page 98, my lord.
Hmm.
98, it says that question number 1, reply, my lord. The reply says that no, the reason why it cannot be applied is clearly written in the recruitment rules. So what they are saying is that it is only for diploma holders, 3 years course diploma holders. However, Your Lordship, in a similar case, which was already disposed of in favor of those petitioners in writ petition number 4281 of 2022, that is at page 113, my lord. Coordinate bench of this honorable court had already
113.
113 had already disposed of the case in favor of the petitioners. 113, this is the first page. My lord, the relevant portion 115. Your Lordship, this is very similar in nature. Let me read from para 1, then I'll skip some paras, my lord. Para 1 says, the 6 writ petitioners herein are holding bachelor's degree in mechanical engineering BE under the Guwahati University, being aggrieved by the refusal on the part of the authorities to allow them to participate in the recruitment process for filling up the 26 posts of motor vehicle inspectors MVI on the ground that they did not possess the requisite qualification as per the advertisement notice. The petitioners have approached this court by filing the instant writ petition seeking a writ of mandamus. Number 2, the facts of the case in a nutshell are that on 13/10/2020, the Undersecretary to the SUMS APSC had issued an advertisement bearing number so and so, inviting applications for filling up of 26 posts of MVIs as per the advertisement notice dated so and so. The minimum essential qualification to apply for the post was HSSLC with 3 years diploma in automobile or mechanical engineer from a recognized institute of government Assam or government of India, and also duly recognized by All India Council of Technical Education. And my lord,
the last portion.
let me come to my lord para 4. Para 4 says that the petitioner has submitted their application in response to the advertisement notice dated according to the APSC. The petitioners did not possess the requisite educational qualification laid down in the advertisement dated so and so. Aggrieved thereby, the petitioners had approached this court by filing the instant writ petition. After taking notes of the facts and circumstances of the case, the learned single judge had passed interim order dated provisionally allowing the petitioners to participate in the selection process. This court had, however, directed that the final results should not be declared. And my lord, let me come to para 10, page 118. Recruitment rules is also exactly similar, my lord. Para 10 says that qualification for appointment in the post of MVI is laid down in the rules of 2003, which reads as motor vehicle inspector, HSSLC with 3 years diploma in automobile or mechanical engineering from a recognized institution of government of Assam, government of India, and also duly recognized by AICTE. So it is very similar. So para 11, this is the operative part. It is clear from the rules of 2003 that the educational qualification prescribed for appointment of MVI is HSSLC with 3 years diploma in automobile or mechanical engineering. The rules, however, do not exclude candidates with higher qualification in the same discipline. And para 13, it is based on the Honorable Apex Court's judgment. In the case of Joyti KK Supra, an issue of similar nature arose for consideration before the Supreme Court. In that case, the Kerala Public Service Commission had invited applications for filling up of the post of sub-engineers electrical in the Kerala State Electricity Board. The technical qualification for the post was notified as diploma in electrical engineering of a recognized institution after 3 years course, study or a certificate in electrical engineering from any one of the recognized technical schools of with 5 years service under Kerala State Electricity Board or MGTE, KGTC in electrical light and power hire with 5 years experience as second LD grade overseer, electrical under the board. The petitioners were holding B.Tech degree in electrical engineering or bachelor degree in electrical engineering were not allowed by the Kerala Public Service Commission to participate in the recruitment process on the ground that they did not possess the necessary qualification as prescribed by the rules. The writ petitioners therein had contended that since they possessed higher qualification, non-consideration of their candidature on the above ground was not correct. As such, a direction is sought upon the Commission to consider petitioners as eligible candidates. The High Court had declined the prayer of the petitioners, as a result of which they had approached the Supreme Court by preferring SLP. While allowing the SLP, Supreme Court had made the following observations in the paragraphs 7, 8, and 9, which are reproduced herein below for ready reference. My Lord, yes, I'll read this
Yes.
para 7 only.
Yes.
It is no doubt true, as stated by the High Court, that when a qualification has been set out under relevant rules, the same cannot be in a manner whittled down and a different qualification cannot be adopted. The High Court is also justified in stating that higher qualification must clearly indicate or presuppose the acquisition of the lower qualification prescribed for that post in order to attract that part of the rule to the effect that such of those higher qualifications which presuppose the acquisition of the lower qualifications prescribed for the post shall also be sufficient for the post. If a person has acquired higher qualifications in the same faculty, such qualification can certainly be stated to presuppose the acquisition of the lower qualifications prescribed for the post. In this case, it may not be necessary to seek far. So, my Lord, here,
My Lord,
after
before go
this, my
further,
Lord-
what I suggest is that
My Lord,
let
my
the issue notice
my Lord, let
tomorrow
me
you can
complete
dispose.
first. Let me
Because
complete
it
first.
has covered case.
Please sit down, Mr.
Yes,
JC. We have not issued notice also. Okay, yes.
My Lord, so para 16, Your Lordship. Para 16, page 121, says that in another decision of the High Court of Judicature of Jammu and Kashmir and Ladakh, rendered in the case of Ramnik Singh and another versus so and so, the division bench had taken a similar view on a similar controversy involved in that proceeding, wherein the court had observed that although the employer may prescribe a particular minimum qualification for the post, the candidates possessing higher qualification would be eligible, provided the higher qualification is
Okay,
in the
so
same
what
line.
is the conclusion is allowed, isn't
It
it?
is allowed. And my Lord, this honorable court in the division bench at page 131, although this another writ petition was filed, wherein the rules, recruitment rules was challenged by this particular, the other petitioners. I have annexed at page
Yes,
131, my Lord.
131. Oh.
The reason why they approached the honorable division bench of this honorable court is that, Your Lordship, in this particular case, they need to challenge the particular recruitment rules, because in the earlier recruitment rules, the particular sentence at least 3 years diploma certificate course was included. But when it was amended, Your Lordship, that at least part was struck out. So unless they challenge this particular recruitment rules, then they may face some problems. That is the only reason why they had challenged the recruitment rules. And in our present case, it is not necessary. It is similar with what I have just read out, the already disposed of case. So, my Lord, page 134, the interim relief,
Okay, so in the other one, at least was to be added.
At least
Or
was
because
struck
at
out.
least was added.
Yes.
They had challenged it.
Yes.
Isn't it? Huh.
So it was necessary
Okay,
for them.
we'll issue notice first.
Yes, and my Lord, 134, page 134, this
Huh, what
similar,
is- huh.
this similar interim interim relief may kindly be given to us, my Lord. Page 134, second para. Having regard to the projection made by the petitioners in the interim, it is provided herein that pending final disposal of the case, the respondent authorities shall allow the petitioners to participate in the recruitment process as was advertised on so and so, subject to the petitioners possessing all the requisite qualification except the diploma certificate in civil engineering. In other words, their applications should not be rejected on the ground that they possess degree in civil engineering and not diploma in civil engineering. It is further provided herein that the respondents shall not publish the result of JE civil without leave of this court. So, my Lord, unless we are given this interim protection by allowing us to participate in the recruitment
What's
process.
the last date of the advertisement? Page, where is the advertisement?
Advertisement was at page 59.
Oh,
And the last date for submission of the application was 12th of August, and we had already submitted.
you have submitted?
We had submitted,
Then when
but-
is the exam?
Exam is next week, Wednesday, 17.
Oh, then.
So, my Lord, time is very limited. So, there is no harm it won't prejudice the interest of the respondents also, my lord. At least we may be allowed to participate in the examination, my lord. That is what this honorable court had done in the other cases also, my lord. Similar cases.
Yes, anyways,
I'm not asking for stay of the advertisement, my lord.
I heard Mr. B. Ladamega, learned counsel for the petitioner, who has filed the instant application for the issuance of the appropriate writ or order to the respondents. Wherein the respondents had denied the petitioners the opportunity to apply for the 3 numbers of post of motor vehicle inspector under the Transport Department, Government of Mizoram, which was advertised by the advertisement dated 10/07/2025 on the grounds that the petitioners, being the holders of the bachelor's degree in mechanical engineer, are barred by the Mizoram Transport Department within brackets Group B post close bracket, then within brackets non-gazetted close bracket recruitment rules, 2006, wherein the rules provided that the educational qualification for direct recruitment should be HSLC with 3 years course diploma in mechanical/automobile engineering from government recognized institute. Full stop. The learned counsel further submitted that the act of the respondents denying the petitioners from appearing for the examination is a violation of the principles of natural justice,
Article
something
14 and 16, madam.
Provided under Article 14 and 16 of the Constitution of India. If by submitting that, a coordinate bench of this court in its judgment dated page
My lord, page 115.
dated 29/07/2024 in WPC
113, madam, page 113. 4281.
page WPC 4281/2022 had decided a similar matter by allowing the petitioners to appear for an examination in spite of them having a higher qualification. Full stop. The learned counsel submits that the instant case is covered by the judgment of the coordinate bench of this court in WPC 4281/2022. Full stop. On hearing the submissions, this court find it fit to issue notice to the respondents. Mr. J.C. Lalnulsanga accepts notice on behalf of respondents number,
5, 6.
on behalf of respondent number 6, while Ms. Vane Isyami accepts notice on behalf of the government advocate, okay, accepts notice on behalf of the state respondents number 1 to 5. Anyone else? Since the respondents are duly represented, no need to issue formal notice. The learned counsel, new para, for the petitioner has further prayed that in line with the order passed by a division bench
Page 131, my lord.
in WPC 32/2025 dated 26/03/2023. The petitioners may be allowed to sit for their examination, which is to be held on when?
17.8, 17.9.
17/9/2025, wherein the result may be
16 and 17, sorry. my lord.
okay, 16 and 17, wherein the result may be subject to the outcome of the instant writ petition. Yes, anything to submit on that?
My lord, actually what I wanted to say is that it can be disposed of if I seek some instruction, that's why.
Okay.
Because it is cover case.
Yes,
That's
yes,
why I wanted
okay,
to say.
yes,
If it
yes.
is said tomorrow or that, it can be disposed of. Because exam is next week only.
Time is very limited,
Okay.
my lord.
Because I'll seek instruction,
problem
it can dispose of.
Accordingly, no, full stop. The Learned Counsel for respondent number 5 submits that, number 6 submits that he may be given time to seek instructions whether the instant case is a covered matter or not, and thereafter the matter can be disposed of
Tomorrow, can you-
expeditiously. In view of the above submissions, list the matter tomorrow.
Yes, my lord.
Tomorrow is the DB day.
My lord,
Okay, we'll
my
do
lord,
it in
at
the
least
afternoon.
in the-
If it's the, we'll fix it tomorrow. If
This
it cannot be, if it cannot be disposed of, then we will consider a interim case.
Yes.
Okay, list the matter, tomorrow's date, wherein the prayer for interim order may also be considered if necessary. Yes, if necessary, we'll consider.
Much obliged.
Submission, item 2.
Yes. I can't hear you. Please speak on the mic. Yes.
I'm appearing on behalf of my senior, Mr.
Yes.
Rajiv Nunga, who is having personal difficulties today. May I request that the kindly matter will be released Thursday.
So the counsels for the respondents are supposed to file their counter affidavits. Have you filed?
Your Lordship, on behalf of the state respondents, the additional affidavit has been filed on the 25th of August.
Okay, already filed. CGC?
Lordship, on behalf of respondent number 1, we have not yet filed.
So when will you file?
I cannot say the exact time, my lord, since we have not yet received any instruction from the
So
concerned
call them,
authority.
contact them. Have you contacted the respondents?
Yes,
Number
my
1.
lord.
Union of India. What did they say?
We did not receive any instruction till date.
So we'll have to fix some other day. You were praying for the matter to be listed on Thursday, but we are still waiting for the respondents number 1. We'll fix another date. Let's see. And then we'll see how long are we supposed to wait. Isn't it? We'll have to put a stop sometime. I think you have to be more proactive. Take the trouble to contact them over phone. Ask them. This is a court case. They cannot simply have the matter pending. There must be some nodal officer in the concerned department, isn't it? You have to push them, because in the Union of India, if they're a party, the concerned department, they have a lot of work. So what happens is the CGC or the councils appearing for such departments, they have to be very proactive. They find out who is the nodal officer concerning the cases. They call them over phone. They push them to do their work because they have other duties also. So you have to be very proactive. Contact them. Find out what's going on. Remind them before the court date, about 2 or 3 weeks before. This is the next court date after 2 weeks. What are the steps taken? They may be also lost as to what is the case about. They'll ask you again. Then again, you will have to inform them, this is it. And we had sent a copy on this date by this. Okay. Because I remember at one time I was working in Shastri Bhavan for some time. You have to, some of the states are very proactive, the government advocates, they call every time. In Mizoram, you have to do your homework. Anyways. Mention is made on behalf of Mr. Lalbiaknunga Namte, Learned Counsel for the petitioner for adjournment of the matter since the Learned Counsel is not able to appear due to some personal difficulty. Full stop. Ms. Baby appears on behalf of Ms. Zairam Sanghui, Learned CGC, for respondent number 1, along with Ms. So-and-so, Learned Government Advocate for the state respondents. It is submitted that the state respondents have filed their additional counter-affidavit. Meanwhile, the Learned CGC has prayed for further time to file their counter-affidavit since they have not received any instructions. In view of the above, we may allow, in view of the above, list the matter after 3 weeks. Yes.
Item 3.
May it please your lordship, this is an appeal against the order. It should be an order, but it's written as judgment and order in the said impugned order 17/12/2024, passed in CMA number 462 of 2023, whereby the application for setting aside ex parte order filed by the present appellant was rejected by the court of Srilaram Sangha, Civil Judge, Senior Division 1, Aizawl District, Aizawl. The facts of the case is that, my lord, the present respondent number 1, who is the owner of an excavator, had filed a suit for payment of the hiring charges of his excavator against the present appellant as well as the other respondents. The other respondents, such as respondent number 2 to respondent number 6, are all first-class contractors who have been allotted the contract work. And the present appellant is the supervising engineer from the Public Works Department. And due to the claim made by the respondent number 1 stating that the present appellant had himself executed the contract work, the judgment and order was passed against him, whereby he was directed to pay for the hiring charges of the excavator. However, the present appellant had done an inquiry of his own, and it was revealed that, my lord, if your lordship may kindly turn to page 132. Page 132 is the power of attorney executed by R. Lian Tuanga, who is the...
No, but this FOAO is an appeal against which order? Read the order.
Appeal against the order dated 17/12/2024.
What does that order say?
This says that, my lord,
The operative part,
the-
why have you come to this court?
yes, my lord. I'll start reading from paragraph 9, Roman 7, my lord. On perusal of the record, it is evident that the impugned ex parte order was passed on 23/1/2019. Before ex parte order was passed, summons were issued to the applicant defendant number 1. Perusal of the record shows that summons dated 7/4/2015 bearing memo number so and so clearly shows that the applicant defendant number 1 himself had duly received and signed the said summons. Thus, it is clear that the applicant defendant number 1 was well aware of the present case, even after the ex parte order was passed against him. the applicant defendant number 1 continued to appear before the court on 18/2/2020, 9/3/2020, and on 13/5/2020. Although he may not have been aware of the said ex parte order, then the court passed the judgment and order on 13/12/2021. However, the applicant defendant number 1 never appeared before the court after 13/5/2020 till final judgment was passed on 13/12/2021. It is clear that the instant application for setting aside ex parte order dated 23/1/2019 was filed only on 24/2/2023, and it is clear that the applicant defendant number 1 never paid attention and neglected his case since 13/5/2020 till 24/2/2023. And as such, the ground that the applicant defendant number 1 was not informed of the ex parte on dated 23/1/2019 cannot be sufficient ground for setting aside the said ex parte order in the light of the second proviso of Order 9, Rule 13 of the Civil Procedure Code, 1908.
So let's concentrate on this. So what's wrong
No,
with
my
this
lord,
order?
if the fact is that the hiring charges should have been paid by the contractor, and the bill has also been withdrawn by the contractor in the said contract work. So why should the supervising engineer be made liable for the hiring charges of an excavator in a contract work? That is
That's
the
a
reason-
different matter. It's against this ex parte, isn't it?
Yes, my lord.
Uh,
This page 132 and 133. 133 is the check by which the sum of rupees 52 lakhs 1,364 has been withdrawn by the contractor in respect of the contract work.
I'm
So,
not understanding your case, huh?
my lord, the fact is that what I'm trying to say is that the court must come to a conclusion, and the court must arrive to a decision where there are false claims, and although there are procedural lapses, the court, when it comes to find out the truth, it must be on that path, my lord.
Then you approach the same court to reconsider.
I approached the
it,
same court, it has
Uh,
been rejected, my lord.
Where is it rejected?
It has been, the orders I've just read out, my lord.
No.
It's an ex parte judgment and order. The ex parte judgment and order would be,
So if it's a ex parte judgment and order, you're going to file an appeal or what? The case is,
it's an ex parte judgment and order, so I filed an application
So
for setting aside
the ex parte judgment, then you can concentrate only on the reason why the ex parte order was passed, not on the facts of the case or what?
My lord,
Why is it
there
only
are
on that
certain- There are
ground?
certain judgment of the apex court saying that procedures are handmaid of justice. And I have been allowed to raise only the procedural lapse. And in fact, when there is already in evidence that the bill has not been taken by me, it has been taken by somebody else, why should I be made liable? The court eventually knew the truth, and the court should apply its mind.
Yeah.
That is what I'm trying to say, my lord. And there is a several judgment of the apex court
This
saying
is
that
basically concerning your appealing against the ex parte
ex
order.
parte
isn't it?
order
Oh.
saying that I should be given.
Anyway, come back to the facts of the case. I don't know what you're trying to impress, because I thought this is an appeal against an ex parte
Yes,
order.
it's a
So
feeling-
what is the date, whether notice was duly issued, whether you knew about the case or what?
I'm just trying to state the facts first because your lordship may be more clear when I come to my submission.
Read the full order. What does it mean? Huh. Read.
This is not an appeal against the ex parte judgment and order. This is an appeal against the order by which an application for ex parte judgment order to set aside the ex parte judgment order was rejected by the trial court.
An application.
An application. It should be in the form of an order, but the trial court had said judgment and order. That is why it's a bit confusing, my lord. It should be an order. This
Anyway, we'll admit it. We'll list some other day for hearing.
my lord, can we have it today? Because
What?
the facts are very little, my lord.
Anyways, heard Mr. Zoram Chana, learned counsel for the appellant. Anything, we'll admit and listen for this thing hearing on some other day.
My lord, there is an urgency. The urgency is that they are filing an application for execution and they are trying to attach my house. They are trying to sell my vehicle and they are trying
Okay,
to attach my
then
salary.
you file an IA for, connected with this to stay the whatever execution, if there's one, isn't it? File an IA connected with this. Yes,
My lord, some technicalities is there because I am not appealing against the impugned ex parte judgment order, but I'm appealing against the rejection of my
okay.
application.
Yeah.
That is the problem, man.
Learned counsel for the appellant also heard Mr. T. Lalzikima, learned counsel for respondent number
1, my lord.
1. Comma, Mr. Zodin Puyanamte, learned counsel for respondent number 2, 3, 5, and 6. Is it? Then who else? Mr.
Respondent number 4, ma'am. K. Vandal Naipuya.
K. Vandal Dinpuya, is it?
Nay.
Naipuya, learned counsel for respondent number 4. And Ms. Lalnunlui, learned government advocate for respondent number 7 and 8. On hearing the submissions made by the learned counsel for the appellant, this court find it fit to admit the instant appeal. This is the matter for hearing. In the next week?
Next week, madam.
The next week. Next week, anytime, both the parties be present, we'll hear for hearing.
Yes, my lord. Obliged, my lord.
You see, when it's for admission hearing, this court also just sees
Yes,
whether it
yes.
should be admitted. It appears to be, yes.
Obliged, my lord.
Item 4.
Yes. Mediation. Would you settle the matter?
No, my lord.
Not settled?
Rejected by the respondent. My lord, I'm for the respondent number 3 and 4.
Oh,
So I have asked whether they want to settle through mediation or not. So my lord, but some technicalities involved in this matter, my lord. So they don't want to pursue the matter before the mediation, my lord.
what is the matter about?
Regarding the regularization of the master role
Okay.
employee.
You are for the, you're appearing for the private respondents?
3 and 4, my lord. There are no private respondents.
Okay, 3 and 4 is what? Which department?
Mizoram State Cooperative Marketing.
Okay,
Mizo Fit.
cooperative. Oh, so regularization, Okay. Then what is the stage? Have you filed your counter affidavits?
No, my lord, I'm seeking another 3 weeks' time to file my affidavit.
What about the cooperative? Have you filed your counter affidavit?
No, my lord.
Then you have to file.
Be final, my.
Mr.? Yes, your good name. Petitioner, what is your good name, please, Mr.?
Simon Asylum.
Assignment Asilo, learned counsel for the petitioner is present, along with Ms. Vani Siami, learned government advocate for the state respondents, and Mr. S. Vandal Shiata, learned counsel for respondents number 3 and 4. Good, full stop. The learned counsel for the respondents have prayed for further time to file their counter affidavits. In view of the above, list after 3 weeks.
Item 5.
My lord, in this case, the state are yet to file their affidavit.
Yes, Lordship, on behalf of the state respondents,
Yes.
it is submitted that the parawise comments have been received. However, there were some ineligible pages. So, therefore, Your Lordship, if 2 weeks may be granted, Your Lordship.
Okay. Mr. Silal Fagzwala, learned counsel for the petitioner, is present, along with Ms. Lalnunlui, learned government advocate for the state respondents. Full stop. The learned government advocate submits that though parawise comments have been received, however, there are some illegible paragraphs which needs to be clarified. She has therefore prayed for 2 weeks' time to file the counter affidavit. Good stuff. The new para, in view of the above, this the matter after 2 weeks.
Status quo may be maintained.
Meanwhile, as granted earlier, status quo may be maintained till the next date of listing.
Obliged.
Much obliged, Your Lordship.
Item 6.
May it please Your Lordship, I am appearing on behalf of the state respondents 1 to 5. This is the second time this matter has been listed. I am yet to receive pairwise comments, Your Lordship. So your 3 weeks time may be granted.
Okay, Ms. Vanaswamy appears on behalf of the petitioners, while Ms. Lal Nundlui, learned government advocate, has prayed for further time to file their counter affidavit. In view of the above, list after 3 weeks.
Much obliged, Your Lordship.
Item 7.
Your Lordship, we have recently filed a power for the private respondent number 7, Your Lordship.
Okay.
And if the matter, we will need time to file our counter.
None appeared for the petitioner, while Mr. Jonathan
El Silo.
El Silo, learned counsel, submits that he will be representing respondent number,
7.
private respondent, is it?
Yes,
The
Your Lordship.
private respondent number 7. Stop. Ms. Lal Nundlui, learned government advocate, appears on behalf of the state respondents number
1 to 4 and 6, Your Lordship.
1, 2,
3, 4
3,
and 6.
4, and 6. Who is for 5? No, 6, 4, 5, and 6, isn't it? While Mr. Rampur appears on behalf of respondent number 5.
My lord, I'm appearing for respondent number 5.
Yes, for respondent number 5. Yes. The learned counsels for the respondents have prayed for further time to file their counter affidavit. Now, instead of none appeared for the petitioners in the beginning, make it Mr. Attila Nunsiama, learned counsel, appears on behalf of the petitioners. Yes. So we will list after 3 weeks for them to file the counter. All the parties are duly represented. Yes.
Hearing item 8.
Your Lordship, may it please Your Lordship, on behalf of the state respondents, even though this matter has been listed for hearing, the matter has been resolved through mediation. So the case can be resolved.
Resolved mediation? What was the matter about?
Lordship, this is regarding the electrocution case.
Oh, so what was the compensation amount to be paid finally?
Lordship, 20 lakhs.
20 lakhs. You had demanded how much?
25, Your Lordship.
25. Very good. It will be paid within 3 months.
3 months, Your Lordship.
Okay, we'll pass the compromise decree accordingly.
Right, Your Lordship.
Yes. Anything else? No hearing matter today? Oh, I thought there was one hearing matter. No?
One is for 11th Thursday.
Okay.
Say,